You trusted them, you built a life, had a child, and when the relationship ended, you agreed on a path forward. Part of that path was child support, a promise to your child that both parents would provide for them, no matter what. But now, the payments have stopped. The phone calls go unanswered, the texts are met with excuses, and the financial weight of raising your child is suddenly all on your shoulders. You're juggling rent, groceries, school supplies, and doctor's appointments alone, feeling overwhelmed and betrayed. If this is your reality, I want you to hear this loud and clear. You are not powerless, and you are not alone. The law is on your side, and today, we're going to walk through the exact steps you can take to enforce your child support order and secure the financial stability your child deserves. This is Law Unwrapped, where we simplify the legal world to empower your future. Let's start with the most fundamental point. Child support is not a favor. It's not a suggestion or a handshake agreement. It is a legally binding court order. When a judge signs that order, it becomes a legal duty, just like paying taxes or following traffic laws. It's a direct command from the court, and ignoring it has serious consequences. Every single payment your ex misses doesn't just disappear. It accumulates as a debt known as child support arrears. Think of it like a running tab that they legally owe your child. The court has a very long memory, and it can enforce the collection of these arrears for years, sometimes even decades, after your child becomes an adult. So, the first step is to shift your mindset. This isn't about asking for a handout. It's about enforcing a legal right your child already has. Now, before you can take any official action, you need to get your ducks in a row. Step 2 is to document everything. The legal system runs on proof, not just your word. So, become a meticulous record keeper. Create a simple spreadsheet or a dedicated notebook. For every missed or partial payment, log the date it was due, the amount that was supposed to be paid, and the amount you actually received, if any. But don't stop there. Gather all related evidence. Save bank statements that show the absence of deposits. Screenshot text messages or emails where your ex makes excuses, promises to pay later, or acknowledges they are behind. If they told you something in a phone call, send a follow-up text confirming the conversation, like, just to confirm our call, you said you can't pay this month's support because of your car repair. This creates a written record. The clearer your documentation, the stronger your case will be. Anger fades, but evidence wins in court. Once your records are organized, it's time to take action. Step 3 is to contact your state's child support enforcement agency. Every state in the U.S., and most countries, have a dedicated government office designed specifically for this purpose. These agencies are powerful allies, and their services are often free or very low cost. When you open a case with them, they can deploy a whole arsenal of enforcement tools. They can access federal and state databases to locate your ex and their employer. One of their most effective tools is wage garnishment. This means they can issue an order directly to your ex's employer, who is then legally required to deduct the child support amount from their paycheck before your ex even sees it. The money is then sent directly to you. But that's not all. They can intercept state and federal tax refunds. Imagine your ex waiting for a big refund check, only to find out it's been redirected to cover their child support arrears. They can also suspend professional licenses, driver's licenses, and even passports. They can place liens on property, like a house or a car, meaning your ex can't sell it without paying off the child support debt first. These agencies do the heavy lifting for you, so you don't have to face your ex directly. However, sometimes the agency's process can be slow, or your ex might be self-employed or hiding assets, making it harder for the agency to collect. In that case, you have a more direct and powerful option: filing a motion for contempt of court. This is step 4. Filing for contempt means you are formally telling the judge that your ex is knowingly and willfully violating a court order. You're not just saying they can't pay. You're saying they won't pay. This is a serious accusation, and it requires a court hearing where you will present your meticulously documented evidence of non-payment. If the judge agrees that your ex is in contempt, the consequences can be severe. The judge can order them to pay a lump sum immediately, sentence them to jail time until they comply, order them to pay your attorney's fees, or impose other sanctions designed to force compliance. A contempt motion sends a very clear message: the court will not tolerate the deliberate neglect of a child's financial needs. Now, it's important to acknowledge that life happens. Step 5 is understanding modifications. Sometimes non-payment isn't malicious. Your ex might have genuinely lost their job, suffered a serious injury, or had another legitimate and substantial change in circumstances that makes the current support amount impossible to pay. If that's the case, the burden is on them, not you, to take legal action. They must file a motion to modify the child support order with the court. They can't just decide on their own to stop paying or to pay less until a judge officially signs a new order changing the amount. The original order remains in full effect, and the debt continues to accumulate. If your ex tells you they can't afford it, your response should be calm and firm. I understand things can be difficult, but you need to file a modification request with the court. Until then, the current order stands. The court decides, not them. This brings us to step 6, knowing the true extent of your power. We touched on some of these enforcement tools, but let's really unpack them. Wage garnishment is the most common. Tax refund interception is incredibly effective. Liens on property ensure that you get paid if your ex tries to sell major assets. The court can even order the seizure of bank accounts. And here's one many people don't know about: retirement funds. In some cases, a qualified domestic relations order, or QDRO, can be used to collect child support arrears from an ex's 401k or pension plan. The law has created numerous pathways to ensure that money intended for a child gets to that child. You have more leverage than you think. Don't be intimidated. These tools exist for a reason: to protect your child's well-being. Finally, and this might be the hardest part, let's talk about step 7. Protect your child, not your anger. It is completely natural to feel hurt, angry, and betrayed. The financial stress is real, and the emotional toll of feeling like you're doing it all alone is immense. But when you step into the legal arena, you must lead with facts, not feelings. This process is not about punishing your ex or getting revenge. It is about securing your child's legal right to financial support from both of their parents. Stay calm, be organized, and focus on the goal: your child's stability. Keep your communication with your ex brief, factual, and focused on the issue of support. Let your documentation and the legal system do the talking. Wasting energy on arguments won't get you paid. Solid evidence and consistent legal action will. Child support is not a weapon to be used in a fight between ex-partners. It is a lifeline for your child. It ensures they have food, a safe home, clothing, and the opportunity to thrive. When your ex stops paying, your first instinct might be to argue, but the most effective path is to act, document, file, and let the system work for you. The law stands with you, and, more importantly, it stands with your child. Thank you for joining me today on Law Unwrapped. I hope this gives you a clear and empowering roadmap. If this was helpful, please give this video a thumbs up. Subscribe for more legal insights, and share it with anyone who might need to hear this. Remember, you've got this.